gelmişti. Özellikle haberleşmenin içeriğine ilişkin olarak ceza kanununda olmakla birlikte biz de idare müeyyide uyguluyoruz. İşletmecimiz eğer bu konuya ilişkin olarak bir önlem almamış ise buna ilişkin yapılan inceleme ve verilen cezai müeyyide. Diğer bir konu yine kişisel verinin ne kadar ehemmiyetli olduğunu anlamamız açısından işletmeciler alt bayilerini sizin abonelerin kişisel verilerini açıyorlar. Yani isminiz, soy isminiz, aboneliğiniz, bu pakete ne zaman abone olduğunuz. Ancak alt bayiler farklı operatörlerin alt bayisi olmaya başladığı anda farklı maksatlarla kullanılmaya başlanıyor. Siz Turkcell abonesisiniz ya da Vodafone abonesi olduğunu düşünelim. Ya da internet sağlayıcısı işte Türk TT.net abonesisiniz. Diğer rakip operatör sizin tüm verilerinize hakim olabiliyor. Ne zaman paketinizin sona ereceğini, ne zaman işletmeciyle sözleşme imzaladığınız gibi verilere vakıf olarak bu verileri farklı maksatlarla kullanabiliyor. İşte yine bizim görevimiz bu verilerin hangi kapsamda kullanılacağı, alt bayilere açılacak bu verinin hangi ölçüde açılabileceğini belirleme oldu. Biraz önce bu teknolojinin imkanlarından yüksek düzeyde faydalanma diye bir balık açmıştım. Onun ilişkin bir açıklama. Şimdi kişisel veri, biz yönetmeliklerle kişisel verinin üçüncü partiye verilmemesini hüküm altına alıyoruz. Bununla birlikte yine direktiften kaynaklı olarak belli durumlarda ambulans, kolluk güçlerine ya da acil yardıma ihtiyacı olan ve bu hizmeti veren kuruluşlara açılması gerektiğini bir istisna hükümle izin veriyoruz. İşte bu istisna hükümden hareketle şu anda ülkemizde özellikle polis teşkilatı ya da sağlık kuruluşlarına vatandaş aradığı zaman 155'i arayan kişinin konum bilgisinden yararlanarak bu şahıs şu anda buradadır bilgisiyle paylaşılmasına izin verildi ve bu paylaşma neticesinde bir örnek vermek gerekirse Ankara'da ilk buna izin verdiğimiz hafta Ankara Sağlık İl Müdürlüğü'nün bize aktardığı veri ölüm oranlarında 5% oranında bir azalma oldu şeklinde bir açıklaması oldu. Tek sebep, en önemli sebep ambulansın kişinin bulunmuş olduğu yere hızlı bir şekilde ulaşması nedeniyle. Şimdi ilgili mevzuatla süremi de geçirmek istemiyorum. Çok kısa olarak buna ilişkin olarak BTK olarak 2004 yılında bir düzenleme yaptık. Yönetmelik çıkardık. Ancak bu düzenleme daha ziyade 2002-58 sayılı direktifin ülkemiz şartlarında, koşullarında uygulanmasına ilişkindi. Bir diğer bir yönetmelik elektronik haberleşme güvenliği yönetmeliği ise bu 27001 standardı var. Belki teknik arkadaşlarımız varsa bilebilirler. Fiziksel güvenliği sağlamaya yönelik olarak. Yani o binanın güvenliğini biz nasıl sağlayabiliriz? Buna yönelik olarak çıkarılmış bir yönetmelik. İlk yönetmeliğimiz özellikle 2006'ya 24 sayılı bu terör olayları olmasının akabinde İspanya'da, İngiltere'de 2006'ya 24 sayılı direktif çıktı malumunuzdur. O direktif ve 2009 yılında çıkan direktif esas alınarak revize çalışmamız yapılmıştır. Önümüzdeki günler içerisinde yayımlamayı düşünüyoruz. Peki neler vardı diye baktığımız zaman çok kısa bahsedecek olursak trafik verisi hangi durumlarda paylaşılacak? Konum verisi hangi durumlarda paylaşılacak ve bunun sınırları ne olacak? Buna ilişkin olarak düzenlemelerimizi burada açıkladık. Vakitten dolayı hızlı bir şekilde geçiyorum. Evet, gelinen son noktada şu şekilde bitirebilirim. Bizim BTK olarak tabii mecliste görüşülmekte olan kanun tasarısının bir an önce çıkması bizim yaptığımız düzenlemeler açısından da çok faydalı olabileceğini öngörüyoruz. Bunun için BTK'nın belki elektronik haberleşme sektöründe oyun alanını belirlediği ama işletmecilerin oyunun bizzati aktörleri olduğu bu alanda karşılıklı koordineli bir çalışmayla ve yasal çerçeve BTK tarafından bu sektörde çizilmek koşuluyla vatandaşlarımızın maksimum düzeyde hizmet almasına ilişkin olarak kurumların özellikle etkin bir şekilde çalışarak düzenlemeleri çıkarmasının gerektiğini düşünüyoruz. Teşekkür ederim dinlediğiniz için. İnşallah süreye uymuşumdur genel müdürüm. Evet.
Ben süreye fazlasıyla uymuş oldunuz. Ben 10 dakikanız var dedim. O konuşmacımız biraz yanlış anladı galiba. Ama erken bitirdi ve zaman kazandırdığı için teşekkür ediyorum. Ben 10 dakika ve 2 dakikalık notlar ürettim kendimce haber vermek için ama fakat teşekkür ediyoruz. Sayın Roberto Latanzi'ye daha çok vakit kaldı ama o da zannediyorum 20 dakikalık süresine uyacaktır. Buyurun.
Good morning, everybody. First of all, I have a problem. I've broke my watch, so as you see, please tell me when I should finish. But second point, let me first thanks a lot all the organizer here. We are not too much in terms of numbers in this room today, but it's interesting to see that the Turkish Bar Association was able to meet together the legal part of the academics, the technical part of the academics, part of the government, part of the relevant independent authority in the area, and it doesn't happen quite often. It doesn't happen quite often. And moreover, there are not only institutional representatives, as we are, in one sense, but we have also experts coming from Germany, giving experience in different areas. So, if it would have been happen in Italy, a similar meeting, I would have been very glad about that. So this is the first reason why I want really thanks you for inviting me in Turkey. I come back after 1 year, more or less. I had in the past contact with the Sabancı University through the MODAP project in Brussels, where I was serving as national expert at the European Data Protection Supervisor for circa 2 years. And later, when they organized an international conference where also Fatih was present last year in Istanbul. And I see that in 1 year, many things are changing. Many things are changing. So there is a draft law. We could discuss about the content of the draft law. I have not been asked to speak about the draft law, but there is a clear imprinting in this law that push Turkey in the direction of the European Union legal framework. And that's not good in itself, obviously, as we, one of the central point of the European Union is unity in diversity. Unity in diversity. It means that we respect the legal tradition, the cultural tradition of each member state, and in the meantime of the third countries. But there is a common level, there is a minimum level that we respect within the Union, and we ask to the third country to respect. This is the level of the respect of the fundamental rights. As Professor Berber said, this is human rights. I will say is the human rights of the third millennium. As I understand the need in terms of policy, negotiating with the European Union to have a comparable legal framework in this area. As Mustafa Taskin said, data protection is one of the prerequisites in order to exchange data between European Union and third countries like Turkey. And obviously this is one prerequisite in order to have a smooth flow of data, not only in the area that is very sensitive of policy and justice, but also in the area of economics and cooperation between a public administration. So this is the reason why there is a pressing need for Turkey, as for other countries, to introduce a legislative framework in this area. So this is I would say, we have common tradition. Rome and Istanbul, at least, has common tradition, common roots in the past. This is a pragmatic argument. We need this law. That's good. The point is that this law is not as any other laws. And the Data Protection Board or authority, as we say, is not as any other independent authority as any other public body. I will be back to the presentation, but the intervention in the first part are much more interesting than a presentation that can remain on the paper. So I'll take the advantage of give some impression. I see that Turkey is in a very close situation as it was Italy before introducing the data protection laws. You have to know that we were one of the last countries in Europe to have a data protection laws. The last one was Greece, but we were just before Greece. And for reason that was very close to the reason that Mustafa Taskine said. So we were not the first of the class. We have done a lot of, we have increased very, very quickly after that, as these kind of laws are not the traditional law that are released within the Ministry of Justice. It's not a law that is written by the bureaucrats, by the people that usually draft law. This is said in Germany is a Professorenrecht. So the principle of these laws comes directly from the thought of some given professor in Europe under the influence of American studies and American automation in the 60s. So it's true what Yüksel Eats said. It's not a new law. It's true that there are few articles probably now in Turkish that will grow very quickly as all things, but they are always changing. So we can say that this area is an evergreen area in the laws. It was a Professorenrecht. So there was some distinguished professor, I will say, in Europe. First of all, Professor Simitis, that conceived this kind of general principle that is quite easy to declare. Finality principle, lawfulness principle, pertinent necessity principle. It's quite easy. I'm speaking here to lawyers. Most of you are lawyers. You know that this is a particular legislative technique, that is the use of general clause. But the general clause need to be adapted in given framework, in given application, in given areas. And the first subject to apply this kind of law will be the Data Protection Board. The Data Protection Board will be and is taught to be in the law and in the European Charter of Fundamental Rights as the engine, the heart of the data protection laws. If you will not have, and for this reason, the European Court of Justice condemning Germany regarding the full independence of the Data Protection Board, Germany, that is the father of the data protection law in Europe, condemning that, they are sticking on the point of independency of the Data Protection Authority. And you have to be aware that the only independent authority mentioned in the European Treaty is the Data Protection Authority. The other could be more important, I can say. Obviously. I would say the central bank, the communication authority, the antitrust authority, they are all important. They are regulatory authority. But the only one mentioned in the European treaties, twice in the Charter and in the Treaty of the Functioning of the European Union, are the data protection authorities. Why? As they are directly connected to the democratic nature of each member state. So you cannot change this element without changing the nature of the European Union. For this reason, I was saying that data protection laws and data protection authorities are not general as any other laws, as any other authorities. They are in the core of the institutional legal framework in the European tradition and in the tradition of European member states, in the constitutional tradition of the European member states. And I see also in your constitution. Then the point is that the data protection is a difficult issue. Why? Not for the principles that are written in the law. We have experiences. Just as a jurist, I was assistant professor at the university before joining the data protection authorities, and we study a law as any other laws, no more, no less. But when I will stay only on one principle of the data protection law, the principle of lawfulness. So the fundamental stone of this law is that every data protection has to be fair and lawful. When you say that it's fair, is the bona fide clause, okay? We don't have the time to discuss it now. I will stay on the lawfulness principle. When you say that a data protection has to be lawful, it means that the data protection laws stay in relation with all the laws of your legal system. With all the laws of your legal system. It means that it has to do, and the German says that the data protection area is a Durchschnittmaterie, so is an horizontal matters. It has to do with family laws, it has to do with bank law, with communication law, with insurance law, and workplace law, a lot of issues. E-health, digital agenda, all these things will interact with the data protection law. As the core of the data protection law is the notion of personal data. And Professor R.K. Savage has clearly stated that personal data are not only name and surname of one individual, but can be found in different ways, having just 2 or 3 elements. And in the area of electronic communication, this is quite normal. So it's really interesting to be here, not only as I love to come back here in Turkey when I have the opportunity, but as is always intellectually stimulating to discuss about these topics, also with new countries, with new people, with different legal tradition, respecting them, but making clear that this is the reason why data protection laws remain a difficult area. And we have 4 levels of laws in the times. They start in the 60s, they will change in the 70s, and every 10 years I will say, and now we are running always in a stricter time, we are changing and adapting this law to the changing environment. But they are strictly connected with the society and with the use of technology within the society. So it's not a law as we as lawyers we are used to speak. When we are speaking about personal data, we are speaking about the freedom of the people, not the physical freedom. Not the physical freedom. But if you know information about individuals, you take decision based on this information. This is the reason why it's important and is the basis of a modern democratic society. Now, we can try to arrive to the task that was asked to me, to speak about the data protection authorities and to the Italian experience. So we were the last one of, thanks a lot, we were the last one of the class, but we made a lot of jump, I will say, as if it's true that Professor Simitis was the father of the data protection laws, we can say that also Professor Rodotà in Italy was not the mother, but he was sitting, for example, in the commission that wrote the Charter of Fundamental Rights, and he was one of the writers of the Article 8. And Article 8 is the article that differentiates the data protection, how it functions, from the respect of privacy. I haven't spoken about privacy. If you take care, I have spoken about data protection till now. Thanks a lot. There are two different things. And is this one? No. No, I don't think so.
What is the name of it? What is the name
Yes. I have.
Do you have any?
Yes, I have the key.
Yeah.
Could
I
be
take it.
useful.
Yeah.
Yeah.
Yeah, okay.
There are a lot. Yeah. Wait. This is my son. Huh? This is a private. Was quite young.
There isn't any infringement of data protection.
No. I give with my consent. So. Okay, but I will speak. It's easier and it's less my money, my Turkish money. It's okay. I will speak about it. Yes, my son. So one of the points is that data protection is not only data security. It's not only data security. So why the Data Protection Authority is important is the engine in my perspective. Not only in my perspective, is in general is the engine of this change. As there is a difference between a judge and a Data Protection Authority. The judge can decide only in one given case. So it's true that one of the tasks of the Data Protection Authorities is to make sure that complaints are being solved, individual complaints, but usually we use the complaints, the one complaint as a case, as the top of the iceberg. But the task of the Data Protection Authorities is to look to the iceberg in itself, to the problem. In this sense, when we speak about privacy by design, about the need to build the information infrastructure within a country in a way that is responding to the laws, not to the data protection law, to the laws, the general laws in the country, we are exactly taking the point of what is data protection in a modern society. So I'm sure that you will not stay only with this data protection law when the law will be adopted. You will need to adopt new sectoral laws. If you are doing a program within the state of e-health, you will need to have a legislative framework in this area, applying the general principle in that area. So we'll need to work in strict cooperation with other stakeholders. This is one of the area. And the subject in this cooperation, thanks a lot. The natural subject is the Data Protection Authority. Now I will run about that. This is more or less the history, and there is a mention of the treaty and the Article 8 of the Charter. And you will see that compliance with this rule, with the data protection rule, shall be subject to the control by an independent authority. So this is the constitutional, we say the constitutionalization of data protection laws and data protection authority. Was said also by other speakers that the Directive 95/46 is the heart of the data protection laws within the European Union, and in the Article 28 there are the tasks of the supervisory authority that I found more or less here represented. What is interesting is that you know that the directive is now under revision. Not all the authorities in Europe have the same power. There are, I would say, strong authorities, and the Italian one is between them, and weak authorities that can give only recommendation, that they cannot impose fine, they cannot really do inspection, and so on. If you look now at the draft regulation that is going to be discussed within the European institution, you will see that the power of the data protection authorities are going to increase, and one of the models of the new draft regulation was the Italian solution, the Italian power of the data protection authorities. They are very different between them, and we will face them later. I want to use my last 4 minutes, I think, going directly not to the task in the directive, but to the Italian experience. But first of all, I want to speak about the sentence of the European Court of Justice concerning the Federal Republic of Germany that is speaking about complete independence, in the sense that the Court of Justice says that this Data Protection Board cannot receive any instruction from private or public body. And actually now, currently there is another infraction procedure against Hungary, as the board was terminated before the natural expiration of the body. And the Commission opened an infraction procedure against Hungary as well. So what are the main features of the Italian Data Protection Authority? I see a lot of similarities also in your laws, also in the number, probably as the number of Italy and Turkey is quite close. You are 70 million more or less, we are 60. But it's different. There is a difference between the draft law and the Italian experience. Most of the members of the panel in Turkey should be, but you have said that is under discussion, this point, if I have correctly understood, comes from the government. The Italian experience is a particular one, as they come from the parliament. And we have 2 chambers in the parliament, we have 4 members in the panel, and the first question is always, what happens if they are 2 against 2 in voting a decision? Okay, the president wins, but it's interesting. I think it's interesting. Every member of the parliament has only 1 vote. So what happened, and the parliament more or less is divided in 2 main areas. One is link-oriented, just to simplify things, and one is right-oriented. So what happens always in Italy is that we have 2 members that are oriented on the left and 2 members that are more oriented on the right. But in 15 years, all the decision, except I think 2 decisions, was always adopted unanimously. It means that they are forced to find the right compromise, and this is typically the role of an independent authority that is not to guarantee one part of the country, their aim is to guarantee the fundamental rights and the interests of the country, of all the citizens. So using this tool, 2 and 2, there is no majority predefined. They had to discuss about the topics and to find a common solution. This is one of the differences we have. So 4 members, a president, and they elect their own president. The 4 members elect their own president between them. There should be individual ensuring independence. They should come, but not always it is happened, to be honest, from the legal experience. They should have legal experience and computer science experience. As if you think that technology is not important in this area, you are releasing a law that is dead from the first day. Is dead from the first day. We are no more in the 60s, we are in the 3rd millennium. Technology is part of our life, of the life of this young child that we have in the first row looking at us. So we are thinking to them, not to the past. Tasks and powers, just running through the task and power just to see how many tasks are in the hands of the data protection authorities. Compliance with the law, reports and compliance, they have to handle reports and compliance lodged by the citizen, prohibiting and blocking some data processing, controlling processing, carrying out inspection. We have a very strong inspection body, for example, that is very... This is the part about oversight power and inspection power of the authority. I will say it's not the most important task of an authority. As we are 125, you are managing to have 150 more or less people, 70 millions. It's impossible to be confident that the data protection authorities can control effectively all the data protection that are done. So the first task of a data protection authority cannot be to make controls. As we all have crimes in our countries, and we have thousands of policemen, and in any case the crime remains. So the main task, this is one of the tasks, it's not the main task, obviously. The main task is to give opinion to the legislator and to the government about how the technology is spreading in the society and how the fundamental rights can be effectively respected. So we go to the other tasks and powers. And one of the most important tasks is this raising awareness of privacy. This is one of the reasons why I'm here. And is to collaborate with the other data protection authorities and contributing to community and international activities. The other way is to adopt code of practice. So what we do, we cannot look at every data processing, but we spoke with all the stakeholders adopting code of conduct, soft law, especially for you that are working within the Department of Justice. You know that it takes a lot of time to have a law. A good law is something that is very difficult to have. And it's very difficult to have to speak with all the interested parties. So you can have a general law, it's classical. Then you have regulation or bylaws as you prefer in a given sector, but not too much. Okay, in telecommunication there will be a law probably, as there is a directive. But what about bank, insurance, strong economic power that will resist to a law in this area? Obviously, they will resist, as it happened in Italy. And also the public administration will be resisting to this kind of law, as there is a Copernican change with this law. In the past, the data controller, before this law, any data controller can say, the data that I have are my data, you are not entitled to know them. After this law, there will be a change. As the principle is the data relating to me, I have the right, and I can enforce the right before the board and before a judge to know what are the data you have in your hands. And take care. This is a gross advantage for the economy. This is a large advantage in the term of efficiency and efficacy, as a lot of data are wrong, are old, are not useful. So you will have some resistance, and you have to save two goods. The first one is the fundamental rights of the individual, but the second one is the growth of the economy, the efficiency of the public administration. Data need to be used, but only the data that are necessary, that are pertinent, that are not excessive, and that are collected respecting the laws. So task and power is raising awareness. The other one is, and we are coming here to the data protection as the first legal counselor, I would say, of the government and the parliament. Through different tools, giving opinion about laws and regulation, sending a report every year to the parliament, and drawing parliaments and government attention on given issues. If they are speaking about data mining and geolocation data, for example, the government could not be aware about this topic. And the data protection is the channel, the institutional channel, this is the reason, that can put forward this topic to the parliament, to the government, saying, look, here we have a problem. We could solve the problem in this way. So it's a central tool in order to have a good information infrastructure respecting the rights of the citizen. Now, just 2 words on the Italian structure of the authority. That can be interesting. If you want, then we can have question and answer. We have 125 people, more or less. The budget comes from the Ministry of Economy, and in 2010 was 13 million euros. 13 million euros. In part comes from the government, in part comes from the fine we give to the data processing sector. We have 4 main areas, 4 main legal departments. The first one is relating to business and profit-seeking entities. I was the head of this department before going in Brussels. So it's the private sector. It's the department that has to do with the industry. The second one is the public freedom and healthcare, is the public department. The third department is relating to communication and electronic network, telecommunication and internet. And the fourth one, that is mine actually, is about public and private job. As being coming back from Brussels, they have decided for the time being to allocate part my international activities and twinning activities also to this department. Then we have a lot of other areas. This is important to understand that there are so many tasks within an authorities that you have to speak. These are the areas. I don't stay on this point. I go to the other service that are the legal and judicial matter, as we can stay before the court, defending our decision or intervening in cases that are discussed. We have then a press office. As public awareness, you need to have a good relation with the public, to the press. We have an inspection service, a front office for the population, an international department, and so on. So it's a very articulated area. I don't stay on this one. What is interesting in this area is that the data flows around the world through the network. So international cooperation is essential in this area. You cannot think to a law that is only a law made in Turkey, or to a data protection authorities that is only looking at the national things. As everything is passing through the network, so you need to be open to maintain your cultural background, so it's local. To be global and local at the same time. And this kind of initiatives make clear that this seems to be the direction that Turkey wants to have, or part of the Turkish society at least. A last remark, more institutional. It's not easy when you will adopt the law. When you will adopt the law and when you will create the agency, as the Turkish parliament will decide to have an authority, what is sure that within 6 months there will be thousands of letters of complaints arriving to the DPR. This is the experience of any member states. There will be everything will be privacy. As we are, as men and women, we find naturally the need to be free. And if something relates to us, we say that our privacy is infringed. It's not always true. It's not always true. But the people think in this way, and the first post office will be the data protection authorities. So there are tools also to approximate, and there is the twinning exercise that is done also with European authorities, and that the Turkish authority can do in the future. This is a tool that is often used, and is a way to exchange opinion and find good practices that cost less to the state that is entering in the club. You are entering in a club. This is an international club in one sense, and is very is strongly asking in terms of human resource, and as was said by Professor Berber, in terms of cultural change. It's not a law. It's a change. You are introducing a change in your culture in the meantime. Thanks a lot. Thanks a lot.
Sayın Latanzi'ye de çok teşekkür ediyoruz. Kendisinin sunumunda süre kısıtlaması yapmadık. 30 dakikayı tamamladı. Gerçekten çok güzel bir sunum yaptı. Aslında dediği doğru. Zaten bilinen şeylerden ziyade İtalya tecrübesini anlatmış olması bizim için hakikaten değerliydi. En son söylediğinden yola çıkarsak biz aslında başımıza neler gelebileceğini az çok tahmin ediyoruz. Kanun çıkmakla, kurum kurulmakla sorunlar çözülmüyor. Hatta sorunlar yeni başlıyor. Bunun bilincindeyiz ama tecrübelerden faydalanmak tabii ki çok önemli. En az sorun olacak şekilde kanunu çıkarmak çok önemli. Sayın Akpınar da bahsetti. Esasında hem kamu kurumları hem özel sektör aslında kanunu bekliyor. Kanun ne getireceğini de aşağı yukarı tahmin ediyor. Buna göre bir hazırlığı var mı? Yok. Biz hazırlığımızı yapmıyoruz. En son ticaret kanununda bunu gördük. İşte yasalaşma sürecine çok yaklaşınca, yürürlüğe girme sürecine çok yaklaşınca kanunu okumaya, tasarıyı okumaya başlıyoruz. Bana ne getiriyor demeye başlıyoruz. Bir takım sorunlar yaşanacak ama biz bunu en az hasarla atlatmaya çalışacağız. Ben hem Sayın Mustafa Taşkın'a hem Sayın Akpınar hem Sayın Latanzi'ye sunumlarından dolayı teşekkür ediyorum. Sorularınız için vakit bırakmak istiyorum. Buyurun.
Okay, teşekkür ederim. Ben KPMG'den katılıyorum. Adım Erol Lengerli. Benim sorum özellikle İtalya uygulamasında ve İngiltere uygulamasında sektörün milyar dolarlara kadar etkilendiğini biliyorum. 10 milyarlarca dolar çapında bir standartizasyon, sistem standartizasyonu ve süreçlerin Covid'den başlayarak 27.001 ve BS 10.012'nin uygulanması bir huni gibi düşünürsek, Covid'den sonra 20 sonra düşünürsek, bütün bunların hazırlığı, sertifikasyonu, denetlenmesi ve denetlenebilmesi için de yapılandırılması çalışmalarının bir farkındalıkla, awareness'e başlatılması gerektiğine inanıyorum. Ben de KPMG temsilen burada hazır olduğumuzu belirtmek istiyorum. Çünkü bu işleri yapan bir firmayız. 140 bin kişilik bir firmayız dünya çapında. Burada 650 kişiyiz. Ben de elimi taşın altına koymak isterim şirket olarak. Dolayısıyla fikirlerini almak isterim ben Roberto Bey'in özellikle İtalya uygulaması ve Avrupa Birliği'nde uygulayan ülkelerin bütçeleri ve buna yatırılması gereken zaman ve para hakkında biraz daha detaylı bilgi alabilir miyim?
So, first, this law is an opportunity for enterprise like yours, you could be happy. But it depends. So you take two examples, UK and Italy. It's your choice, was not my choice. Huh? And there is an idea that we, as Mediterranean and southern countries, are usually the idea is that we are bureaucratic and costly, okay, while the northern country, like UK, should be much more efficient, more liberal, I will say this word simply, and so on. Now take the case of data protection and data protection authorities. And the notification, you have asked about that. I see that there is a provision in the law, and probably is an old provision. Now we'll come back, for the reason I try to explain. As the devil in this area, the devil is in the details. We all agree with the general principle, but when we put in practice this principle, then there are a lot of problems. So thanks for the question, in any case. Regarding the notification, this is an old issue. In the very beginning, the idea was, in the very beginning means in the 60s, the idea was that the computer could represent a risk for the individual. Therefore, there should have been, every data processing should have been notified. This was the idea why the CNIL, the French authority and the French tradition, was exactly in order to give a license, that is the notification process, to each data controller. This idea was, in one sense, contrasted, but Bettina Keller can add something about that, from the German experience that was much more, and the Scandinavian experience, as there was a widespread of computer and automation, and the idea was that it was not possible to notify each data processing, as there are millions of data processing. And you close the data protection authorities if you say that they have to make a register of each data processing. So the Italian arrives later, but they learn the experience, and we are the first driver of the change now in the draft regulation written in Brussels, in the sense that we adopted the opposite principle of the directive. So the idea in Italy is that a data controller has not to notify each data processing, but only some data processing that are meant by the law to be at risk, to put at risk the fundamental rights, and to have enough flexibility. The law empowered the Garante, so the Italian data protection, to make a new list when it was necessary. UK, and for us, you have to do the notification only in this case, only once in the life of the enterprise, and it costs, if I don't forget that it's not my, I'm not very interested in that, but it's interesting, it costs 150 euros. Usually you can introduce in Turkish lira? Okay, 300 Turkish lira, once, forever, and only for given data processing. What happens in UK? More or less, as far as I know, I don't know if they are changing, but in UK, every data controller has to make the notification every year, paying a large amount of fees every year, and not for simplified data processing. What is the reason? Is the data protection authorities is funded in this way. So just to say that, but the reaction in the economic enterprise that we have in Italy, we have a lot of medium and small enterprises And we cannot, we didn't found justified to put this kind of fee that is a tax of them. So when we speak seriously about simplification of duties and so on, we have to think to each of the duty that any law provides, as they are cost for the people. And if you are putting too much duties, the reaction is an adverse reaction. They say that they don't accept the laws, and the Ministry of Justice will be facing the industrial representative and the other saying this law is too much onerous for us. So it's really an interesting exercise. A second and last comment about that. You say that your enterprise could be happy to give, as I think, academics first of all, to give good quality of education in this area. And probably there could be a synergy and a lot of things. Let the market open, as we say. Huh? What is important is that who does the work better work. But if the point in this area is to make sure that this fundamental right is effective, and this was the first thought in Germany, is to say that it's true that the data protection authority is the cornerstone. It is really my opinion, and was my opinion when I was in the university. It's the cornerstone of the data protection laws, but it's necessary, but it's not enough. And the decision that was taken in Germany, for example, and now is followed in France as well, is to have the data protection officer at the level of significant enterprise of public bodies that make sure that the law is correctly applied. And this is the direction that now we have different names. In France is le correspondant à la vie privée. In Germany is the danke. But the betriebliche Datenschutzbeauftragte, okay. And this figure now is in half of the member states, more or less. This is a solution that is not written here, for example, but is going to be introduced in the draft regulation that is under discussion in Brussels. But they are fighting about the level and so on, about the details. Really, to be serious in this area, to be serious, we should go and read line by line each law and saying what is the effect in the society, we can afford that, this will work or will not work. In this sense, an exchange of, for this reason, you have to speak with the other experience around the world in order, without prejudice. So one prejudice is that the southern countries are slow and the northern are skilled. That's not always, huh? Often, but not always.
Teşekkür ediyorum. Yemek saatimiz geldi ama çok kısa soru ve çok kısa cevaplar olursa bir iki soru alabiliriz. Yoksa öğleden sonraki konuşmacılara soracağımız sorularda şimdi sormamıza gerek yok. Takdir sizin, soruların önünde kesmek istemiyorum ama anlayışınız için teşekkür ediyorum. Özür dilerim eğer engellediysem. O zaman yemek arası için ara veriyoruz. Katılımcılara teşekkür ediyorum.
Onları bekleyecektim ama bir zaman alacakmış gelmeleri. O yüzden ben ikinci oturumu başlatmak istiyorum izninizle. Bu bölümde 4 konuşmacımız var. 2 yurt dışından misafirimiz var. Bird Hukuk Bürosu'ndan partner olarak bir misafirimiz geldi. Benoit van Esbroek. Right? Yes. Okay. Ve Almanya'dan, Privcom'dan Dr. Bettina Kahler bizimle beraber. Bilgi Üniversitesi'nden Dr. Nilgün Başalp. Sabah Yüksel Bey'in İlk Türkiye'de tez yazdığı diye bahsettiği ama benim ve Nilgün arasında gidip geldiği isim Nilgün'dü. 2004 yılında kişisel verilerin korunmasına ilişkin ilk yüksek lisans tezini Türk hukukuna Nilgün kazandırdı.
Hocam da Leyla Keser Berber idi.